A conservative Republican federal judge just delivered what sources are calling the most humiliating legal defeat the Trump Justice Department has suffered, and the way he did it might have effectively exonerated journalist Don Lemon while exposing the administration's authoritarian tactics. We're not talking about partisan Democratic judge issuing expected ruling. We're talking about reports that Chief Judge Patrick Schultz, a Federalist Society member and former Justice Scalia clerk, wrote extraordinary letters to the Eighth Circuit Court of Appeals that systematically dismantled Pam Bondi's attempt to force his court to arrest a journalist. That he documented how the DOJ's tactics were unprecedented and unheard of in his district or any other. And sources suggest what might make this moment so devastating for Trump is that Judge Schultz didn't just reject the legal theory. He allegedly wrote that two of the people DOJ wanted arrested were not protesters at all. Instead, they were a journalist and his producer. There is no evidence that those two engaged in any criminal behavior or conspired to do so. When conservative judge appointed by George W. Bush effectively exonerates someone Trump's DOJ is trying to prosecute, that's not judicial activism. That might be Republican member of the bench defending press freedom and rule of law against administration that threatens both.
Protesters taunted Border Patrol Commander Greg Bovino outside his hotel as news broke that he has been booted out of Minneapolis by order of President Trump. They were trying to make his last night in Minneapolis a sleepless one. This is how one hotel guest, believed to be an ICE agent, responded. He mooned the crowd.
But before we break down everything, please subscribe to our channel, John Brown Show. Your subscription actually matters here. All right, let's get into what Judge Schultz actually wrote in these extraordinary letters and why sources suggest they represent complete demolition of Trump DOJ's case against Don Lemon. Because this wasn't just Judge expressing skepticism or asking for more evidence. Reports indicate Judge Schultz documented that the DOJ's procedure was unprecedented. That magistrate judge properly rejected arrest warrants for Don Lemon and his producer because they were journalists covering protest, not participants in any crime. That the worst behavior alleged against anyone at the church protest was yelling, with no violence whatsoever. And that instead of following normal legal process after magistrate rejection, DOJ ran to appellate court seeking extraordinary remedy to force judge's hand.
A very, very unfortunate incident. I don't like that he had a gun. I don't like that he had two fully loaded magazines. That's a lot of bad stuff. And despite that, I say that's a very unfortunate incident.
When conservative chief judge writes that there's no evidence journalists engaged in any criminal behavior or conspired to do so, that's not leaving door open for future prosecution. That might be definitive statement that case has no merit. And sources suggest that's why multiple grand juries have convened since these letters were written. Yet none has returned indictment against Don Lemon. When your own case gets demolished by Republican judge before it even reaches jury, prosecutors might recognize they have nothing worth pursuing. Let's start by establishing what actually happened at this church protest that Trump DOJ tried characterizing as major crime requiring arrest of journalists. Because sources suggest the gap between reality and DOJ's characterization reveals how desperate they were to punish Don Lemon for his reporting on ICE operations. Reports indicate on January 18, 2026, approximately 5 protesters went into a church in St. Paul, Minnesota. They were protesting someone affiliated with ICE being present at the church. Don Lemon was there as journalist with his producer covering the protest live on YouTube and Substack. Video evidence allegedly shows what actually occurred. Protesters entered church and voiced objections to ICE presence. Some churchgoers appeared displeased. Others seemed supportive. Police were called. Protesters were already leaving when officers arrived. No violence occurred. No property was damaged. The entire incident was brief and uneventful except for presence of Don Lemon documenting it. Think about what that means. This wasn't violent insurrection. This wasn't assault or destruction. This was people exercising First Amendment rights to protest government policy, captured on video by journalists doing his job. But sources indicate Trump DOJ characterized this as major crime requiring prosecution of 8 people, including Don Lemon and his producer. They presented affidavits to magistrate judge seeking arrest warrants and criminal complaints. The magistrate approved 5 but rejected 3, specifically the warrants for Don Lemon and his producer. And the reason reportedly was obvious. These weren't protesters. They were journalists covering the story. Magistrate judge properly recognized distinction between participating in protest and reporting on it. Think about how fundamental that distinction is for press freedom. If journalists can be arrested for covering protests, if presence at demonstration makes you criminal defendant rather than reporter, First Amendment becomes meaningless. Every journalist covering civil rights movement could have been arrested for being present at sit-ins. Every reporter documenting anti-war protests could be prosecuted. That's not how constitutional system works. Press freedom depends on journalists being able to cover events without being treated as participants. Make sure you're subscribed to John Brown Show because sources suggest Trump DOJ understood this distinction perfectly well. They weren't confused about whether Don Lemon was journalist. They knew he was covering the protest on live stream. They arrested him anyway because reporting on ICE operations in ways that might be unflattering to administration made him target. When government prosecutes journalists for doing journalism, that's authoritarian tactic, regardless of what legal theory gets offered as justification. But what Judge Schultz found most extraordinary wasn't just that magistrate rejected arrest warrants. It was reportedly what Trump DOJ did next. Instead of following normal legal process, they allegedly took unprecedented step of seeking writ of mandamus from 8th Circuit Court of Appeals to force district court to override magistrate and issue the warrants. And the way they did it might have been designed to prevent Judge Schultz from even knowing what was happening until it was too late. Sources indicate Trump DOJ filed the mandamus petition under seal, making it confidential. They never served Judge Schultz with papers, so he couldn't see what accusations they were making about his court. And they did all this while Judge Schultz was home on his day off caring for his son who has disabilities. The 8th Circuit contacted him asking for response by 2 p.m. with just hours' notice. And Judge Schultz couldn't even access the sealed documents to know what he was responding to. Think about how irregular that procedure is. Normal process when magistrate rejects warrant application is straightforward. You improve the affidavit and resubmit to same magistrate. Or you take case to grand jury and get indictment, which doesn't require magistrate approval. Those are standard options every prosecutor knows. What you don't do is run to appellate court seeking extraordinary writ to compel district judge to override magistrate. That remedy exists for extreme circumstances where lower court has clearly exceeded authority, not routine disagreement about probable cause. And reports suggest Judge Schultz consulted other district judges. None of them had ever seen DOJ bypass normal process this way. Not once in the history of the 8th Circuit had district court been asked to override magistrate's probable cause determination through mandamus. That's how unprecedented Trump DOJ's tactics were. When something has never happened in entire history of federal circuit, that's not vigorous prosecution. That might be abusive process designed to intimidate judges into compliance. But there's allegedly another element that made this particularly egregious. Filing it under seal and not serving Judge Schultz meant he couldn't defend his court's decision, couldn't explain why magistrate properly rejected warrants, couldn't present facts showing Don Lemon was journalist rather than protester. Trump DOJ apparently wanted appellate court to rule based solely on government's characterization without hearing from judge who actually handled the case. That's not normal adversarial process. That might be attempt to obtain ruling through procedural manipulation. Share this video with everyone you know because sources suggest the 8th Circuit saw through it immediately. Conservative appellate panel looked at Trump DOJ's extraordinary request and denied it summarily. No lengthy opinion explaining why, just flat rejection. When your own ideological allies on appeals court won't even entertain your unprecedented procedural gimmick, that indicates you've gone too far. And it reportedly set stage for Judge Schultz to write letters that would destroy whatever remained of case against Don Lemon. But let's look at what Judge Schultz actually wrote in his letters to the 8th Circuit. Because sources suggest these weren't just procedural objections. These were systematic dismantling of Trump DOJ's case, combined with what might be effective exoneration of Don Lemon. The judge started by noting the absurdity of his situation. Reports indicate he wrote that this was first he'd heard of any mandamus petition, that DOJ didn't have courtesy to give him copy. That petition was sealed even from him, and that he'd been given about 2.5 hours to respond to something he hadn't read and couldn't read. Think about the sarcasm in that response. I'm supposed to guess what the petition is about and guess what it says and then respond, so I will do so. That's federal judge calling out DOJ for procedural abuse in a way that makes their misconduct clear to appellate court. When you have to guess what accusations are being made because government won't even serve you with papers, that's not normal legal process. That's ambush tactics. But Judge Schultz didn't stop at procedural objections. Sources indicate he went further to address substance. He wrote that it's unheard of and unprecedented for DOJ to try overriding magistrates' decision this way. That if government doesn't like magistrates' ruling, proper remedies are improving the affidavit and resubmitting or taking case to grand jury, not running to appellate court seeking mandamus. That explanation reportedly makes clear Trump DOJ knew what proper procedure was and deliberately chose to ignore it. And then came what might be the most devastating part. Judge Schultz addressed the actual facts of the case. Reports indicate he wrote, "The 5 people whom the government seeks to arrest are accused of entering a church, and the worst behavior alleged about any of them is yelling horrible things at the members of the church. None committed any acts of violence." Think about what that establishes. Even accepting government's characterization at its strongest, there was no violence. Just speech. First Amendment protected speech, however horrible the content. But sources suggest Judge Schultz went even further in follow-up email. He wrote, 2 of the 5 protesters were not protesters at all. Instead, they were a journalist and his producer. There is no evidence that those 2 engaged in any criminal behavior or conspired to do so. That's not leaving door open for future evidence. That's Judge who has reviewed the affidavit stating definitively that evidence doesn't support charges against journalists. When federal judge writes there's no evidence of criminal conduct, that's effective exoneration that makes prosecution nearly impossible. Make sure you're subscribed because there's reportedly another dimension. By characterizing Don Lemon as journalist rather than protester, by noting he and his producer were just doing their jobs, Judge Schultz protected press freedom. He established that covering protests doesn't make you participant in them. That journalism is constitutionally protected activity that can't be criminalized just because government dislikes the coverage. That precedent matters beyond just this case. It protects other journalists who might report on ICE operations or other Trump administration activities. But here's why Judge Schultz's letters might have ended any possibility of prosecuting Don Lemon. Because sources suggest that when federal judge issues such definitive statement that evidence doesn't support charges, prosecutors face impossible tasks convincing grand jury to indict. Grand juries typically trust judges' assessments. If chief judge says there's no evidence, grand jurors might wonder why they're even being asked to consider charges. And reports indicate Trump DOJ appears to have recognized this problem. Multiple grand juries have convened since Judge Schultz's letters were written. Yet there's been no presentation about Don Lemon to any of them. No indictment has been returned. Sources on the ground suggest prosecutors aren't even trying anymore. When your case gets demolished by conservative judge before reaching jury, you might calculate that pursuing it further just creates more embarrassment. Think about what would happen if they did present to grand jury. Defense could introduce Judge Schultz's letters showing federal judge found no evidence of criminal conduct. Could show video proving Don Lemon was journalist covering protest, not participant. Could demonstrate that magistrate properly rejected warrants based on insufficient probable cause. Grand jury would see that every legal authority who reviewed this case concluded there's nothing there. That makes indictment unlikely even if prosecutors wanted one. But there's reportedly another factor. Judge Schultz challenged DOJ to go to grand jury if they thought they had a case. That challenge still stands. If Trump DOJ believed their case had merit, they could present it to grand jury right now. The fact that they haven't, despite multiple opportunities, might indicate they know they'd lose, that Judge Schultz was right about evidence being insufficient, and that pursuing prosecution would just generate more adverse rulings documenting abuse of process. And sources suggest this mirrors pattern with other Trump DOJ political prosecutions. They tried twice to indict New York Attorney General Letitia James for mortgage fraud. Federal judge dismissed first attempt. Grand jury rejected second attempt. That's multiple failures to prosecute someone Trump views as enemy. They got indictment dismissed against James Comey. Pattern emerges where Trump DOJ's politically motivated cases collapse when subjected to normal legal scrutiny. Judges and grand juries refuse to rubber stamp prosecutions that lack legal merit. Now, what happened with Don Lemon might establish that pattern continues. Reports indicate Trump can order prosecutions of journalists and critics, but judges appointed by both parties and grand juries drawn from communities recognize abuses and reject them. That's legal system working as check on executive power, even when president wants to weaponize Justice Department. And it's particularly significant when Republican judges are ones shutting down the schemes. But step back and look at what Judge Schultz's intervention means for press freedom under Trump administration, because sources suggest this case represents test of whether journalists can be prosecuted for covering government actions that administration wants suppressed. If DOJ succeeded in arresting Don Lemon for reporting on ICE operations, that would send chilling message to every other journalist covering immigration enforcement or other controversial policies. Cover protests at your own risk. Document government misconduct and face prosecution. Think about how that would transform journalism. Reporters would have to calculate whether covering certain stories worth risk of arrest. News organizations might pull journalists from covering ICE operations or protests or any situation where presence could be characterized as participation. Government could effectively suppress coverage of its most controversial actions by making journalism itself criminal. That's not how free press works in constitutional democracy. That's authoritarian control of information. But Judge Schultz's clear statement that journalists covering protests aren't criminals reportedly protects against that outcome. By distinguishing between participation and documentation, by recognizing that journalism is constitutionally protected, he established precedent that other judges can follow. When next journalist gets targeted for covering Trump administration activities, defense can cite this case, can show that federal judges reject prosecutions based on journalists doing their jobs. And sources suggest this matters particularly in Minnesota context. ICE operations there have generated enormous controversy. Killings of Alex Prey and Renee Good. Aggressive tactics that federal judges are now finding violate constitutional rights. Journalists documenting these operations are providing essential accountability function. If they could be prosecuted for that documentation, public would lose crucial window into government misconduct. Judge Schultz protecting press freedom preserves that accountability mechanism. But there's reportedly another element. Trump administration's willingness to prosecute journalists for covering church protest reveals how far they'll go to suppress unfavorable coverage. This wasn't Don Lemon committing violence or property destruction. This was him live streaming protest and conducting interviews. If that's enough to justify arrest warrant in Trump DOJ's view, no journalist is safe. Anyone reporting facts Trump dislikes becomes potential target. Judge Schultz's intervention stopped that in this case, but threat remains for journalists covering administration activities. Sources suggest there's also international dimension. When American government tries prosecuting journalists for covering protests, international press freedom organizations take notice. When Republican federal judge has to intervene to protect journalists from his own government, that's concerning signal about state of democracy. Judge Schultz's letters might have prevented worse international fallout by demonstrating American judicial system can still check executive abuses even if those checks come later than they should. But the Don Lemon case reportedly isn't isolated instance of Trump DOJ suffering humiliating defeats in Minnesota. Sources suggest this is part of broader pattern where Pam Bondi's Justice Department keeps losing when subjected to normal legal scrutiny by judges who actually read the law. Judge Schultz ordered ICE director to appear for contempt, and administration released detainee rather than face hearing. Magistrate judges keep rejecting warrant applications. Federal judges are documenting systematic violations of court orders. Each defeat reportedly adds to record of DOJ dysfunction and abuse. And it's not just Minnesota. Reports indicate Judge Roy Dalton in Florida sanctioning prosecutors for willful wholesale failure to cite contrary law. Multiple federal judges finding Trump's immigration tactics violate constitutional rights. Pattern of courts pushing back against administration that treats judicial rulings as suggestions rather than binding requirements. When judges across different jurisdictions reach similar conclusions about violations, that's not judicial activism. That might be documentation of real lawlessness requiring judicial intervention. Think about what this pattern reveals about Trump DOJ's approach. They apparently don't expect to win on merits. They expect judges to defer to executive power regardless of legal requirements. When magistrate rejects warrant, they seek mandamus rather than improving case. When court orders bond hearing, they ignore it rather than complying. When judge threatens contempt, they release detainee at last minute to avoid accountability. That's not confident prosecution. That might be abusive process that only stops when consequences become unavoidable. But sources suggest the consequences are mounting. Pam Bondi's deputy Lindsay Halligan resigned in disgrace after judges rejected her work. Multiple Trump officials are facing contempt proceedings. DOJ's credibility with federal judiciary is reportedly collapsing as judges document repeated violations and abuses. That reputational damage could affect every case DOJ handles, not just politically motivated prosecutions. When judges stop trusting Justice Department's representations, that creates problems for legitimate prosecutions too. And there's reportedly political dimension. These judicial defeats are happening as Trump's approval craters and midterms approach. Democrats can point to Republican judges rejecting Trump DOJ's tactics as evidence of bipartisan concern about authoritarian behavior. Can argue that even conservative jurists recognize administration has crossed constitutional lines. That's powerful campaign message that transcends partisan accusations. When your own party's judges are shutting down your schemes, that indicates real problems rather than political disagreements. Sources suggest Trump administration's response to these defeats has been firing officials rather than changing tactics. Border Patrol Chief Greg Bovino got removed. DHS Secretary Christine Noem allegedly sidelined, but firing people doesn't fix underlying legal problems. Courts will still reject unconstitutional tactics regardless of who implements them. And new officials face same accountability mechanisms that led to their predecessors' failures. Until administration decides to follow law rather than trying to circumvent it, defeats will continue. So what actually happens now with Don Lemon case and Trump DOJ's broader efforts to prosecute critics and journalists? Because sources suggest Judge Schultz's intervention might have established precedent protecting press freedom while exposing administration's authoritarian instincts. Reports indicate DOJ has publicly acknowledged they're not seeking arrest warrants against Don Lemon through magistrate process anymore. But they've left open possibility of grand jury indictment, and multiple grand juries have convened without any presentation being made. That suggests DOJ might be quietly abandoning prosecution while avoiding public admission of defeat. Sources indicate when federal judge issues such definitive exoneration, prosecutors recognize pursuing case further just creates more documentation of abuse. Better to let it fade away than generate additional adverse rulings that become precedent constraining future political prosecutions. If that's Trump DOJ's calculation, it means Judge Schultz's intervention succeeded in protecting Don Lemon from politically motivated charges. But think about broader implications. If Trump administration backs down when confronted by determined judges, that establishes that judicial pushback works. Other judges facing similar abuses might be emboldened to act more aggressively. Knowing that Chief Judge Schultz documented violations and issued contempt orders without being overruled could encourage other jurists to use their powers more forcefully. That collective judicial resistance might constrain Trump's most authoritarian impulses in ways that political opposition alone couldn't achieve. However, sources suggest there's also darker possibility. Trump DOJ could be quietly continuing political prosecutions in jurisdictions where they expect more sympathetic judges, using tactics that avoid generating written records like Judge Schultz's letters. Pursuing targets who lack Don Lemon's platform and resources to defend themselves effectively. The Don Lemon case getting shut down doesn't necessarily mean broader scheme to prosecute critics has ended. It might just mean administration is being more strategic about which cases to pursue and how to pursue them. And there's reportedly question about what happens if Republicans maintain control after midterms. If Trump faces no electoral accountability for DOJ's abuses, if judges' resistance produces no political consequences, administration might calculate they can wait out judicial opposition, replace judges when vacancies occur, find prosecutors willing to push cases more aggressively, eventually grind down resistance through sheer persistence. That's why midterm elections might be crucial for determining whether judicial pushback produces lasting constraints or just temporary obstacles. Multiple sources also suggest Democrats will make Judge Schultz's intervention campaign issue. Argument that even Republican judges are rejecting Trump's tactics proves he's crossed constitutional lines. That independent judiciary is standing up to protect press freedom and rule of law. That voters who care about First Amendment and judicial independence should support candidates who will provide congressional oversight. Whether that resonates depends on whether enough Americans still believe those principles matter enough to vote based on them. So here's what Judge Schultz's extraordinary intervention reveals about Trump DOJ's tactics and their limits. A conservative Republican federal judge documented that DOJ's attempt to prosecute journalists was unprecedented abuse of process. That proper procedures were ignored in favor of seeking mandamus to force court's hand. That worst behavior at church protest was yelling with no violence whatsoever. And most importantly, that two people DOJ wanted arrested were journalist and producer, for whom there was no evidence of criminal conduct or conspiracy. Those findings might have effectively exonerated Don Lemon in ways that make prosecution nearly impossible. When federal judge states definitively there's no evidence supporting charges, grand juries typically won't indict. And Trump DOJ appears to have recognized that by letting multiple grand jury sessions pass without even attempting presentation. That suggests they know case lacks merit, and pursuing it further would just generate more embarrassing defeats. The broader implications for press freedom are significant. Judge Schultz established that journalists covering protests aren't criminals. That documentation of government activities is constitutionally protected. That DOJ can't prosecute reporters just because administration dislikes their coverage. Those principles matter beyond this specific case. They protect other journalists who might face similar targeting for covering controversial Trump administration policies. But the pattern of judicial defeats in Minnesota reveals systemic DOJ dysfunction, magistrates rejecting warrants, district judges ordering contempt, appeals courts denying extraordinary remedies, Republican judges appointed by Republican presidents documenting violations and abuses. That's not partisan judiciary opposing Trump. That's federal bench defending rule of law and constitutional rights against executive overreach, regardless of ideological alignment. The question now is whether these judicial checks produce lasting constraints or just temporary obstacles. Whether Trump administration learns that certain tactics won't work and modifies approach, or whether they just seek friendlier venues and keep trying same abuses. Whether voters recognize significance of judges defending democracy and elect Congress that will provide oversight, or whether judicial resistance operates in political vacuum without electoral consequences. The answers will determine whether Don Lemon case becomes precedent protecting press freedom or just isolated victory in losing war against authoritarian creep. Stay tuned.